So, good day everyone. I am Paula May SJ Oroncillo from PCBet 01402A and I will be discussing three topics. The first one is rights of partners in case of liquidation caused by violation or non-violation of the partnership contract. Article 1837. So, hindi ko nababasahin yung buong article na to. Instead, isa-summarize ko na lang siya. This article explains the rights of the partners if the partnership was dissolved with or without violation or contravention. So, what is contravention? It is an action that violates a law. Another is, let me define the dissolution. It is the closing down or dismissal of an assembly, partnership, or official body. So again, this article consists of the rights of partners in case of liquidation caused by violation or non-violation of the partnership contract. So first, let me explain the rights of partnership without contravention or violation. The first one is to have the partnership property applied to discharge liabilities of the partnership, meaning they can sell the partnership property to pay the partnership debt. So, what is a partnership property? It is the subject to sharing among the partners. Partner property belongs solely to the partners. This underscores the importance of determining what belongs to the partnership and what belongs to the partner. In general, partnership property consists of all the property contributed by the partners or acquired by the partnership with its fund. So, a partnership may own real property as well as personal property. Partners hold title to partnership property by tenancy in the partnership or tenants in common. This means that each partner has an equal right to use the partnership property for partnership purposes unless there is an agreement to the contrary. Also, a partner possesses no interest in any specific item of partnership property. For example, a partner does not own 10% of the personal computer which his secretary uses, meaning a creditor of the partner cannot proceed against any specific item of partnership property. A creditor can only proceed against the partner's interest in the partnership. For example, another example is A, B, and C form a partnership for a term of 5 years. After 5 years, they decided to dissolve the partnership and to wind up. X is a creditor of the partnership prior to the dissolution, and partner C also loaned a sum of money to the partnership. During liquidation, the non-cash asset of the partnership must be converted into cash, like selling the properties of the partnership to pay the creditors, like X, of the partnership. Thereafter, if there is remaining cash, then it will be distributed to the partner creditors. This explains also to have a surplus and other rights if the partnership dissolved without violation. So, if any applied to pay in cash the net amount owing to the respective partners. So, it means that if there will be any excess from it, like what I said earlier, they can pay their other debts and they can divide it among themselves. So, the rights naman if there is a violation in the partnership agreement. First, let me discuss the rights of the partner who has not caused dissolution wrongfully or the innocent one. Actually, same lang siya ng rights sa taas, which is to have the partnership property and to have surplus. So, I will explain the one which is to have the partnership property. It means that the innocent one may apply for partner's lien, meaning he or she may use any contribution from the other partner and deduct them to pay the debt caused by other partner. Well, the second one is to have surplus, as what I have said earlier. If there will be any excess from the first one, they can pay their other debts or personal debts and they can share it among themselves also. Another right is to indemnify for damages caused by the one who caused the dissolution. So, let me define which is indemnified first. So, it means that to secure or protect against financial liabilities or a legal agreement by one party to hold another party blameless or not liable for potential losses or damages. So, ito yung advantage ng innocent partner. Another is to continue the business in the same name, either by themselves or jointly with others during the agreed term of the partnership, and for that purpose may possess the partnership property. So, since they are not at fault, they may do it. So, kagaya nga nasabi ko, yung mga innocent partners, mas madami silang advantage kaysa dun sa nag-cause ng damages. Let me discuss also the right of partners sa wrongfully caused dissolution. So, if the business is not continued by the other partners, the partner who wrongfully caused the dissolution may have the partnership property also applied to discharge liabilities of partnership and to receive in cash his share of the surplus minus damages caused by his wrongful decision. So, may kailangan pa rin siyang bayadan aside sa utang ng partnership niya dun sa mga kapartners niya. So, if the business is continued by the other partners naman, the one who caused the dissolution may have the value of his interest at time of dissolution ascertained and paid in cash or secured by bond and be released from all existing or future partnership liabilities. For example, A, B, and C form a partnership for a term of 5 years. On the third year, B in bad faith decided to dissolve the partnership. In this case, it is B who wrongfully caused the dissolution of the partnership. During liquidation, the non-cash asset of partnership must be converted into cash, like selling the equipments and other properties of the partnership to pay its creditors. After paying the creditors of the partnership will pay the creditor of the partnership if any. So, pag nabayadan mo na yung utang ng partnership nyo, pwede mo naman bayadan yung utang mo lang or yung partner creditor. So, at this juncture, the damages to be paid by B must be determined. For example, if the damages was ascertained to be 10,000, this amount will be deducted from his interest and this will be given as an addition to the interest of A and C. So, sabi ko nga kanina, yung aside sa utang ng partnership, yung may kasalanan na partner is magbabayad pa siya dun sa mga kapartners niya para sa damages na na-cause niya. So, in short guys, innocent partners should have better rights than guilty partners, and the rights of the guilty partners are safeguarded by a bond approved by the court and payment of interest at the time of dissolution minus damages. So let's go to my second topic naman. 3 rights of a partner who is entitled to rescind. So, Article 1838. Hindi ko na rin siya babasahin guys, i-explain ko na lang. Pwede nyo siyang basahin habang na-explain ko siya. So, this article means that if a contract is annulled, the injured partner is entitled to restitution. First paragraph, to a lion on right of retention of the surplus of the partnership property after satisfying the partnership liabilities the third person for any sum of money paid by him for the purchase of an interest in the partnership and for any capital or advances contributed by him. So, meaning, he or she may use any contribution in order to pay partnership liability. So, let me define what is a lion. A lion is, so it is a legal right against a property that allows a lion holder to take control of it or take legal action to settle any debts. Lions act as a collateral in a situation where a person can't honor their debts obligation and typically lasts until the debt is satisfied. So what is RESCIND? It is revoke or cancel. To revoke or to cancel a law, order or agreement, to invalidate an act or measure by a later action or a higher authority. What is retention? It means to continued possession, use, or control of something. Second is to stand. After all liabilities to third person have been satisfied in the place of the creditors of the partnership for any payments made by him in respect of the partnership liabilities. So it means rights of subrogation, meaning the substitution of one person in the place of one another or another with reference to a lawful claim, demand, or right, so that he or she who is substitute succeeds to the rights of the other in relation to the debts or claim and its rights, remedies, or securities. The third right is to indemnify by the person guilty of the fraud or making the representation against all debts and liabilities of the partnership, meaning to secure or protect against financial liabilities or a legal agreement by one party to hold another party blameless or not liable for potential losses or damages. So again, the three rights of a partner who is entitled to rescind is to ally on or right of retention. The second one is to stand and to be indemnified. So this is my last topic. Liabilities of the partnership shall rank in order of payment. Basahin natin yung Article 183 na. In settling accounts between the partners after dissolution, the following rules shall be observed, subject to any agreement to the contrary. The first paragraph is the asset of the partnership are the partnership property and the contribution of the partners necessary for the payment of all the liabilities specified in number 2. So, kagaya nga sinabi ko sa partnership property, ito yung property na inuunang partnership. So, the asset is the property of the partnership such as equipment, machine, etc. And of course, the cash. Paragraph 2. So, this explains my report, which is the rank in order of payment. So, yung yung utang nga daw is, yung utang daw sa partnership may order. Yung kung sino yung unang dapat bayadan, yung pinakaunang dapat bayadan, saka yung hindi naman, yung pwede naman siya ihuli. The first one is those owing to partnership creditors other than partners. So, as what I have said, there is an order of payment need to follow. First, the partnership liability. So, yung unang dapat bayadan is yung utang ng partnership. Yung second naman is those owing to partners other than for capitals and profits. So, the second one is the partner or partners who gave a loan to partnership. Excuse me. So, kung una, yung utang ng partnership, yung pangalawa naman is yung individual na utang ng partners. Pangatlo naman is those owing to partners in respect of capital. Take note that an industrial partner is not entitled to participate in the capital because he or she did not contribute money or property or both. The last one is those owing to partners in respect of profits. Another information is an industrial partner is entitled to participate in the profits. So, example, A, B, and C form a partnership with an agreement of equal profit sharing. Their contribution were 100,000, 200,000, and 300,000 respectively. Thereafter, they decided to dissolve their partnership. At the time of dissolution, they have total assets amounting of 1 million. Moreover, at the date of dissolution, the partnership owes X the amount of 50,000, Y the amount of 100,000, and partner C the amount of 100,000. So, Following the order of payment, X and Y have preference being outside creditor. After payment of the liabilities to X and Y, which is the total of 150,000, 1 million less 150,000 is equal to 850,000. Afterwards, kailangan naman bayadan si C as an inside creditor, which is 100,000. So, 850,000 less 100,000 will be leaving a balance of 750,000. Thereafter, partners A, B, and C will be paid as their capital, leaving a balance of 150,000. Which is yung capital, yung investment nila kanina na 100k, 200k, and 300k respectively. So, a total of 600,000. So, 750,000 less 600,000 will leave a 150,000 balance. The remaining 150,000 will be divided by the partners A, B, and C based on their profit sharing agreement, if any. If there is no profit sharing agreement, then it will be based on their capital contribution. Therefore, since they have an equal profit sharing agreement, each of the partners will share a 50,000 each. So, that would be all. Thank you for listening. I hope you understand my report and you learned something today. Good day again.